Hello everyone. So this video is going to be on client counseling. This video is especially for those students who don't understand vernacular language like Hindi. So especially for those students, I am making this video. So in this video, we are going to talk about what should be the structure of the client counseling. In the structure of the client counseling, we are going to we will just divide this structure into two parts. First is what we are going to do in the complete rehearsal or like complete performance, and what we are not going to do in the performance, like what we have to avoid. These things should not be present in our performance. The first thing, well, in case if you want to know what are the essence of this structure, the essence of the structure can be divided into four things. Like first of all, you have to be like have a good relation with the client, like which is based on the trust and rapport. The first thing. Then second, you have to gather maximum information as much as it is possible. And third is like you have to share the role of the client and the lawyer as well. And the fourth is that you have to share this. You have to talk about the charges that you will take against the counseling process or against this complete suit which I going to be deal about. Okay, so based on these four parameters, the structure can be it can be as follows. Like first of all, you will have to greet the client like by shaking your hands and introducing yourself, and you may also add the component that I'm the person who is going to be like counsel you on your legal issue. So the first thing is this. Second thing, that you have to ask for whether you don't have any problem in finding our office. The third is like you have to ask whether the person want to have a coffee or tea or something like that, snacks or anything else like water or something. After that, what you can do, after that you just ask some passive questions, like open-ended questions. Okay, so in which through which like that client is going to narrate his story in a free flow manner. So after once this story has been completed from his side or her side, then what you can do, you just ask some leading questions which is like mandatory in case if you want to know whether this suit is in favor to plaintiff or not, or what are the legal action that already have been taken by the client, or what are the key essentials that are actually required to know in case if you want to win the case. So some leading question you may ask after that, and just after completing the leading question, what is required, that you just tell all the roles of that role of the client as well as the lawyer, in which you just give some the statement of confidentiality. So in the statement of the confidentiality, so you just ask that person whether that all the conversation or the evidences that the client will provide to you will be kept as a secret and kept as a private and confidential. And in case if there is any of the conflict of interest, or due to any reason, in case the client don't want to cooperate with the lawyer, or don't want to have a service of like legal service with the lawyer, so that person can go ahead and will all destroy these all the evidences that we are having related with that issue which you are talking with like client. So just after that, you may provide the retainer agreement. What is a retainer agreement? Retainer agreement is the agreement in which all the charges of consultancy and like e-filing and other charges which is like it is a complete uh, like bill, or you can say it is underlying it is a like agreement. So retainer agreement is an agreement of it is a contract actually. So in this contract actually the client give the payment against the legal service or the professional service which is providing to that client. Okay, so over this counseling you also have to provide that retainer agreement, so that there should be not like bargaining situation in which client is bargaining with you ki I don't do this and that. Although you can mention in your retainer agreement that in case if certain criteria are not fulfilled, so sorry, so in case if certain criteria are also fulfilled related to the financial scenario, then what you can the case can be leaded as a pro bono case. So these are the actual things that you have to mention in your structure, and based on this structure the complete process is going to be very next. So the next is what you don't have to do. Like in case if you just needed to know that you don't have to use many legal jargons first of all. Then you don't have to promise anything like whether you are going to be win the case, or whether based on your these evidences you surely win the case or something like that, because there may be the chances that the defendant person or the other side or other party may have more stronger evidences than that person or that client is actually giving to you. So that also matters a lot. So because of this you don't have to like give any promise. There may be the situation that when you have an idea ki what the other party is also having, what the evidences that other party is also having, and what evidences you are having, like as comparison you are having better evidences, then you can have certain assertion, you can make certain assertions, but then also it's quite good that you just don't promise or like say anything ki ye this is going to be like it is going to be in our case, like this case is going to be in our favor, etc. So these are the two things that you have to mention, you have to maintain it. And third is like you don't have to you have to separate it out, like you have to maintain the separation of professional and personal relationship. You don't have to like you don't have to intermingle your professional relation with the personal one. So please keep the distance of your personal relationship and professional relationship as well. Thank you so much.